The following video will walk you through 4 basic steps to drafting initial disclosures. But first, a couple of notes. As you already may know, the parties must provide for inspection and copying to the other parties the following items: the names, addresses, telephone numbers of each person likely to have discoverable information, a copy of all documents or any other information you have that is not attorney-client privilege, a computation of damages claimed, or how you're adding up your damages. This will apply mostly to the plaintiff. Also, defendants must provide any insurance policies. And all of this is usually done after the early case conference. But check your state rules and your law firm rules. So let's begin. Section 1 will be witnesses. Make a numbered list of each witness, starting with the plaintiff or plaintiff's attorney's law firm name, address, phone number, as well as a brief description of what the witness is expected to testify to, as in this example after number 1. So make additional numbers for any additional plaintiffs. You will also add defendant's name and defendant's attorney's name, address, and telephone number, and a brief paragraph of what he is expected to testify to. So make sure you add all witnesses here. It might include any company security officers, any police officers, any eyewitnesses. Add them to this list. Section 2 will consist of plaintiff's treating providers. So make a list of each treating provider and a brief statement of what the provider is expected to testify to. Most of this language under this heading is basic language for this type of document. And you can delete or add information depending on your law firm preferences. So you will start with adding the name of each provider, hospitals, any radiologists, ambulances, any clinic, and include their street address and their phone number. And that is very simple. All the language below this also is common, and you can read it and delete as needed. Section 3 is going to be a list of the documents that will be produced. You must produce any and all documents available that are not attorney-client privilege. For personal injuries, the basic documents produced include the complaint, the answer, police reports, photos, any witness statements, any document you may have, as well as authorizations for medical records and any medical records from all providers. Bates stamp the documents and then enter the correct Bates number in this section here under Bates number. And the number of the disclosure. In this case, if it's the initial disclosure, it's going to state initial. Once you supplement the disclosures, you will then change it to first sub, second sub, and so on. Also here, if there's a large number of medical records or documents, it would be easier to insert a link. As some courts have limits on the size of the documents that you serve. So it's easier to make a link. And section 4 is going to be computation of damages. You must provide a list of all the medical bills, out of pocket expenses, future treatment estimates, etc., for whatever bills you have. If you know that plaintiff attended has some bill that you don't know the amount to, you can state to be determined or TBD. Also, in case a plaintiff is still receiving treatment, you're not going to have the total amount of the billing. And so add them up here. This is self-explanatory. And the following language here after further, this is also all basic common language for this document. Also demonstrative exhibits. All this is basic language. You can leave that in or you can delete. Date the document, add attorney's signature, and add a certificate of service. Date it and add the opposing counsel's name, address, and add your name to this line before you serve it. And then serve the document. Thank you for watching, and let me know if you have any questions.